What's up, everybody? Not sure who's all tuned in here, but I think they're supposed to get started here soon. It was uh, 1 p.m., 10 a.m., and then they pushed it back to 2 p.m., and now we're at, 2:30 p.m. Eastern time. I heard somebody got arrested in the courtroom. Sylvia, one of the uh, bloggers who's been covering it, that Thugger Daily account, who's so good at covering everything and has been covering it from the get-go, told me that she got arrested on like warrants in the courtroom or something. But so hi everybody. Hope I'm pronouncing it right. Calavia and Paradox. Jasmine, thanks for saying hi. Thanks for saying what's up. Yeah, so my understanding, it wasn't anything like directly related to the YSL case. It's just the fact that like she had warrants out or something. But I don't want to talk too much about that because it's just something I heard. But in the end, it's like if that hadn't happened, like they would have started on time anyway. You know, they'd never start on time. So, but it's motions today. The testimony is supposed to resume tomorrow. I'd heard that one of the defendants got sick, you know, that kind of thing. But it's just the trial that can never, you know, really get going. Like anytime they kind of get going and get some momentum going, something like this happens, and there's like a week-long break. But because I'm assuming, isn't President's Day Monday? So maybe they'll do a day of testimony Thursday tomorrow, and then sometimes they have Fridays off. Usually they have Fridays off for just a half day. So they're going to get like nothing in, you know, they'll have like tomorrow, and then they'll probably have to take Monday off because it's President's Day and the court is probably closed. Somebody asked what's been the delay all week, and somebody was sick. I don't know who, but I just heard from an Atlanta attorney who's in Atlanta and covering the case, or just following the case, and she knows some of the attorneys involved, that one of the defendants was sick. People say it's COVID, but I don't know. I haven't like seen the test results myself or something. And I am kind of like, what? It seems like a couple of years ago when COVID was going around, it was like the recovery time on that was definitely longer than like a couple of days. I'm like, if somebody really does have COVID, it's like, are they really going to be back on Thursday? But they had always planned to take Monday off from testimony because it was going to be like a personal day for the jurors to go do stuff. And the attorneys were supposed to argue motions on Monday, but with one of the defendants being sick, the defendant wouldn't waive his presence. So looks like we might have some action here. So they're doing motions today. I have a list of the motions. Some of it is kind of interesting. They want to redact some information about Jimmy Winfrey's conviction and plea in the I think the Lil Wayne bus case. I'm not sure, but yeah. And then one thing I wanted to say, I'm going to link this in the chat. I've got a story out. I've got a big story out. You know, I'm a writer at heart. I spent my whole career just writing articles and never going on camera and talking about them. So the Young Thug trial, I've been so busy doing clips, which I love doing, but I hadn't really been able to write articles. But I just did like a big piece on this here. They're still not started yet, so let me bring this up. Real quick, but it's linked in the chat. But it's I talked to Bruce Harvey, who's Quamarvius Nichols' attorney, and he said that he thinks prosecutors are going to have to change their approach. But I just talked about like how I went over Angela D. Williams' motion to withdraw, and I think it's interesting that Rodalius Ryan doesn't want her to withdraw. But got into that, talked to Bruce Harvey about that, some of the issues that he's facing as an attorney, just not being able to do any other cases. Put together that collage of all the defendants. Put my name on it because I know somebody's just going to screenshot it and use it on their own website. But oh, and one thing, I mean, looking through this indictment to do this story, I was like, it is truly just absolutely insane that they have spent like the last 3 months on all these petty crimes. When you look through that indictment, there's some pretty serious crimes in there. Like I mean, murders. We've got. I mean, YFN Lucci is all over that indictment. It's. I just can't believe that they've been spending so much time on this petty stuff. Like um, as a writer, do you feel the state has an actual case here, or do you think it's a little far fetched? I think it's just way too big, and the way they've gone about focusing on all these petty crimes over the last 3 months. It's like I think they could have just whittled this down into the Donovan Thomas murder. Okay, here they're starting here. I'm gonna shut up. I can't stand those people who talk over the testimony. So I'm seeing some camera action here. Yeah, Bruce Harvey's cool. We haven't really seen much of him in testimony yet because he works with Nicole Westmoreland, and she's been doing some of the crosses when they have a cross to do. But he's definitely preparing. Like if anyone gets convicted, he's preparing some kind of appeal about all the co-conspirator issues. And he's been kind of complaining about some of the stuff on cross that's been coming in. But one thing, I mean, it's just weird. It's almost like the prosecutors don't want to actually win the way they're focusing on all this small stuff. Because the case is already just going on for way, 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 way too long. And I don't think they... Here, what am I doing here? Sorry. Hey. Oh, here we gotta.
All right, and Mr. Nichols, Mr. Harvey, good afternoon, sir. And then Mr. Ryan and Misty Williams, good afternoon. All right, Mr. Yahelski, Mr. Atkins, Ms. Hilton, Mr. Brown and Smith, good afternoon. Good afternoon. All right. Okay, I appreciate y'all's patience this afternoon. I had to take up some business with our legislature today, I should say, and so that's my delay in starting. So what we'll do is I'll get as much as I can, or as much as we can. My hard stop time today is 4. We'll talk a little bit about what we're going to cover tomorrow. And just see where we are. But I need to take up the lead. We're going to continue tomorrow with Investigator Belknap, is that correct?
Yes, Your Honor.
Okay. How long do you think how much longer do you think we'll have with him? I'm just want you to give me an estimate, that's all. Just for planning.
Your Honor, and good afternoon, everyone, and happy Valentine's Day. Your Honor, I would say 2 hours for cross-examination.
Okay, 2 more hours.
Yes, Your Honor. I'm not sure if that's the only counsel left to cross-examine. If that is, then the state will have about an hour and a half worth of reading. All right.
Okay. Does anybody else have any examination of Investigator Belknap?
You may have to cross, Your Honor. May have some, Your Honor. We may have another 105 motion.
Okay, I can save you the time on that one tonight, okay? Do an order again, okay? All right. Okay. Looking ahead, Miss D. Williams, madam, are you laid on for us to hear your motion is it the 16th, madam? Did I set it the right date?
16th at 9 a.m.
Okay, and you have everybody subpoenaed you need to?
Yes, Your Honor.
Okay, all right, so we'll still plan on doing that morning, okay? Just for planning purposes, so I can tell our jurors and we can plan accordingly. And you also know everybody's tracking that The 19th of February, Monday, is a county holiday, so we will be down that day. But the rest of the week, starting on the 20th, February, we'll work a full day on the 20th, the 21st, the 22nd, and half a day on the 23rd. Of course, that's always subject to other things that are beyond the control of the court. But we'll do the best we can. The reason I asked that, counsels for the state, is it is likely, based upon the representation, that we may or may not be finished with Investigator Belknap tomorrow. That'd be the 15th. And is there any other witnesses or any other, what's your plan at that point in time to call witnesses?
If we don't finish with Belknap tomorrow,
If we, of course, we don't finish them, we'll continue on to Friday. But we should finish, do you have some other witnesses lined up?
yes, we'll be ready to move forward.
Okay, in particular, are any of those witnesses the subject of Mr. Steele's motions that I still need to address?
Yes, motion number 40 and motion number 42.
Okay, give me a second right quick. Okay, motion number 40 deals with certain purported jail calls.
Yes, Your Honor.
Okay, and then what's the other one?
Motion number 42.
That's Mr. Bean, is that correct?
Yes, Your Honor.
Okay.
And then last, for the next set of upcoming witnesses, be motion number 43.
All right. I'll see what we can do about taking care of those. As is necessary. I'll also include, Mr. Steele, your letter to me yesterday of 2 pages with the motions that you have outstanding as the next court exhibit in order.
Can I inquire of the state for a second?
You can, sir.
Thank you.
No. We're going right to Adrian. Yep. Yep. We're not doing that next. We're doing Adrian. Am I sure those are the only ones? I believe. To double check for us, but I believe it's just those 3.
Okay,
You know, may it please the court.
not yet. Thank you. Tim. What journal number is this? What journal number is she? She's 204. She's 204. She's 204. I got it.
Okay.
She's 204. Okay, the other thing I want to kind of take up with you is that the court has gotten some correspondence with juror number 204. I'll repeat, juror number 204. Juror number 204, ladies and gentlemen, is forwarded the court a copy of her lease, and she is moving out of the county starting on, I think the lease contract begins on the 26th of February of this year. So, I want you all to think about what, I don't need an answer right now, but I do need to account for, of course, I can't make her not move, but the question is, the court is trying to, grappling with is, must a juror be a resident during the entire time of trial? This is not one of these situations where we have the applicability of, while we have jury selection and before our jury's impaneled and sworn, but I do believe that it may trigger 15-12-172. And looking at some case law that I've been able to kind of look at so far, I'm going to include the juror's lease as the next exhibit in order. I'm going to order it to be sealed because it has some proprietary data in there. But I can tell you that I have matched that particular person's name with our juror list. They are juror number 207. Okay? All right. 20, hold on, make sure. Before I tell tales, let's go. Hold on. 204, yes. You're correct, counsels. I apologize. 204. Okay. So, I invite you all to look at, and like I said, Bell versus the state. That's 333-66 Georgia App 743, and it talks about trial court's excuse of a juror, replacement of a juror with an alternate. Either I can conduct an evidentiary hearing or I cannot, depending upon what is produced. So she's produced a lease. It's clear she's going to move. The question for us is, will her moving statutorily prevent us from keeping her as a juror. I haven't found any case law that would indicate that, of course, you can be removed for a juror if you're not a resident at the time that jury selection or before a jury is impaneled or sworn. But after that, the court's concern is whether or not she will still be a qualified juror, given that she doesn't live here. So think about it. You all can do some research. I've done some, so has Mr. Kearns, but that is the question that we need to kind of answer before her lease takes effect on the 26th of February. Okay? So I'll circle back with you about that.
Can I add something to that, Your Honor?
Yes.
And please check the record because, that would be best. But I believe I moved for cause. I believe if this is the right juror in my mind. She told us that she would be moving her question on individual idea, and I believe I made a motion for cause for that reason as well as others. So I just don't want later you to say, why don't you raise that to me in my consideration, because I don't want it to be a waived issue at all. So I just want to tell you that. If I'm wrong, though, I, of course, bow down to the record of the honorable court reporter, but I believe that's true.
Yeah, I'll have to take a look at our notes as well, Mr. Steele. And I believe that given the fact that we didn't know whether she would move or not, and then also this has been, it took us 10 months to go through the jury selection. So I believe that if memory serves me correctly, this is a juror that, she didn't know whether or not she was going to move or not, but we'll search the record and find that out. So, Chris, can you look that up for me? Okay. All right. But just, I need you all's input, at least in terms of whether or not she's still a qualified juror if she moves. And that's what I'm trying to kind of ascertain at this point. All right. So we'll circle back with that issue. In terms of, I'd like to take it up maybe tomorrow, just so that we don't run out of road.
Your Honor, for scheduling, are we starting at 9 a.m. tomorrow?
Yeah, that's what time everybody's supposed to report. We're 9.
Okay, thank you.
And we'll get started somewhere between the 9 and 9:30 hour, okay? All right. Okay. Hey, Wes, where did I put all those notes and everything that I have from our jury selection? You upstairs? Where are they? Sure. Okay, now I'd like to move on. Oh, Mr. Matthews, what were you gonna tell me?
Yes, Your Honor. I just want, for the record, to reflect that the defense bar is unable to access the internet to get for these cases and things that we need in order.
What cases?
Well, you just cited 15 you cited the statute.
I printed that before I got here, so
I think you cited a case,
I did Bell versus the state, 366 Georgia, app 743.
yes, we just don't have the access to the internet.
Yeah, we're still having some technology challenges from our recent situation that's belabored our county. So doing the best we can, doing the best we can with that issue. Let me check with our technical support folks and see if there's anything that you're talking about general Wi-Fi?
Yes, Your Honor.
I think I Okay, all right. I made an inquiry. Okay, all right. So, Mr. Steele, let's handle motion limit number 40. I believe that talks about recorded jail calls on behalf of Mr. Williams. All right. Okay, so, Your Honor, these do deal with Mr. Williams' jail calls, but for the purposes, can you tell me what dates you're talking about, sir? For purposes of today, for the next series of witnesses which deal with Mr. Bean, B-E-A-N, Your Honor, what occurs is on, Mr. Bean's another motion. I believe that Mr. Bean is, let's see, which one you have in terms of that. I could do that one, sure. I'll be right back. Mr. Bean is your motion number 42. Mr. Williams, number 40, deals with any of his jail calls.
Yeah, so that's not coming up, and I know you want to do motions that are really coming up. Mr. Williams is not, to my knowledge, his jail calls are not coming up. So with that being said, I could argue 40, but 42 is really ripe for what you instructed us.
Is that true state, or do you, in terms of?
I guess we understood 40 to deal with a jail call in which Mr. Williams is referenced.
Is what, Mr. Williams, is what, I'm sorry?
Is referenced, so that's what we thought number 40 referenced, which was a jail call in which Mr. Bean talks about Mr. Williams in that
That's
call.
number
And that's not
42.
40.
That's number 42. The one that is in 40 is broader. It just gives, well, that Mr. Seal claims that you all will attempt to play jail calls of other persons, not Mr. Williams. So it's kind of, that's broader than in 40, that's 40. And then 42, which indicates a 911 jail calls in the lake of, and it talks about a conversation between, or it says Mr. Bean and Mr. Bean's wife and an unknown male.
Yeah, so then you're correct. Then we only need to hear for the purpose of today, 42 and 43.
Okay. And then 43 covers DNA reports from acts, overt acts 5, 6, and 7, correct?
Yes,
Okay,
Your
all
Honor.
right. So let's deal with the phone call again with the one that references Mr. Bean. And motion number 42, sir.
Yes, sir. Okay, so Your Honor, what happens is it is the 13th day of September of 2013, and Mr. Bean is going to be in a car along with Mr. Prethro, which is Pretho. His first name is Fred or Frederick, as well as Mr. Walter Murphy. The car is parked in an apartment complex. Law enforcement officers are in that same complex for a different reason. Mr. Murphy supposedly walks up to a man named Mr. Dotson, which is D-O-D-S-O-N. Mr. Dotson has a large amount of currency on him. He's with his brother at that point. Mr. Murphy tells Mr. Dotson, you know what time it is allegedly, and tries to arm rob Mr. Dotson. Mr. Dotson, Your Honor, tragically has passed through, not this incident, just as the years went by, he's passed, unrelated to this case or this incident. Mr. Bean is driving, he says he's driving a car. The car then has Mr. Murphy get in it. The car almost kills or strikes a law enforcement officer. Law enforcement officers are shooting at the car in self-defense and to stop the car from hurting others. The car goes through a gate at the apartment complex, goes a short distance, then careens through a person's yard, takes out part of the house, a tree, and it goes off a careen, goes flying in the air, flies over a parked police car. It's just sitting in a parking lot, flies over that police car and slams into the side of a laundromat. It's on Cleveland Avenue. Occupants are either running or around the car. Law enforcement officers are on the scene. Mr. Bean gets away for a short distance, gets over a fence, and he's hit by a police car. He goes underneath the police car. He's arrested. Mr. Fred Prethro is found right at the car. He is shot, Your Honor. Police were shooting at the car. There's some bullet trajectories that crash in through the windows of the car. And then Mr. Murphy is shot in the leg, and he's arrested at or in the car as well. So 3 people accounted for. The issue then becomes there are law enforcement officers on the state's witness list who say that there are 4 people who exit that vehicle. There are some law enforcement officers who say 5 people exit that vehicle. And there's some law enforcement officers who say that 3 people exit the vehicle. Mr. Bean Mr. Murphy is then interviewed he's taken to Grady Hospital. He's interviewed. It's not recorded. And he allegedly states that there were 4 people in the car, according to law enforcement. Mr. Prethro is interviewed at Grady Hospital. He supposedly says it's on recording. There are 3 people in the car. And Mr. Bean is in the Fulton County Jail. The Honorable former retired Detective Quinn gets the case, and he gets involved because it's a police officer shooting at the car and shot Mr. Prethro potentially. So he's investigating that for the APD. And he's also at the scene, and he pulls jail calls. There's approximately 11 jail calls of Mr. Bean. During the jail calls, Mr. Bean discusses things like, I should have run with Thug. He got away. I should have followed Thug, things like that. I'm fine as long as Mr. Bean is a witness. We'll confront him, cross-examine. The issue that we raised before this honorable court is there's an unknown person. I don't know who the person is. To my knowledge, in the state, of course, will correct me. That person's not on the state's witness list. That person's not been identified in discovery. That person's on the calls. There's one call specifically, and I put it in Mr. Williams' motion limit number 42, the specific times. And that person is saying, I spoke with Thug. He said $150 was his for lien that was found in the car or left in the car. And this person's talking about Thug. I'm presuming, for purposes of this conversation, that Thug is Mr. Jeffrey Williams. So I can't cross-examine, the Honorable Chief Adams can't cross-examine that unknown person, and I am asking the Honorable Court to redact any of the statements made by the unknown person. They are hearsay. They are not confrontation clause because I'm not saying that it's being used for trial evidence, for testimony, but I am saying that it's just straight hearsay. The state alluded to the fact that this would be a rule of completeness issue again, and therefore it has to come in to show context. I've listened to that recording. There is no reason to have those hearsay statements come in under rule of completeness under 24-1-106, because different from, let's say, the tweets that the Honorable Court has listened to and ruled upon, these statements are independent. Mr. Bean is the one saying, you don't need to explain Mr. Bean's statements when he's talking about Jeffrey Williams, to have this other person say, oh, and since this time, I spoke with Thug, and Thug said that he left $150 in the car, it was for lien, and that was his money, or something to that effect. So that is what this motion targets. There's another recording. It's Mr. Bean and his mother. His mother is not on the witness list to my knowledge. And again, the state, correct me if I'm wrong. And I don't see why the mother's conversation with Mr. Bean should be played for the jury either. I mean, Mr. Bean's statements are one thing, but not the other person. In addition to that, Mr. Bean, so this happened on the 13th of September. On the 17th of September, Mr. Bean is brought into the Atlanta Police Department interrogation room, Detective Quinn. It is audio taped, it is video recorded as well. And Detective Quinn goes through Mr. Dodson, who's deceased, Your Honor, will not be testifying, God forbid. What Mr. Dodson said, and he talked about Jeffrey Williams. He talks about that the people at the hospital were lying to the police, he believes. So I'm moving to redact all of those statements as well, because that would be based upon, just interrogation, but it would violate Mr. Williams' right to confront it, because that is testimonial, because that is, of course, the detective who is accumulating information to potentially bring a case. Your Honor, I'd like you to also know this and take this into consideration. If you look at the indictment, Overt Act 5, 6, and 7 deals with Mr. Bean's incident. Jeffrey Williams is not named. So I had no notice that Jeffrey Williams is involved in this at all. I did get it in the discovery, of course. And this came, I believe, in discovery number 1. If I'm wrong, it was discovery number 2. But I knew about I listened to these recordings back in, 2022. So I just want you to be aware, we're not charged, but I also want you to be aware that I have had these, discovery appropriately. I'm not saying that it was thrust upon me at the last moment. I think I've covered it. I have case law for you, but it's a straight, not rule of completeness. I don't see any exception to the hearsay rule at all. It is an out-of-court statement, offered into evidence to prove the truth of the matter asserted by this unknown person saying, I spoke with Thug and he said that he left money in the car that would tie Jeffrey Williams to the car. Mr. Dotson's statements to law enforcement would be, of course, confrontation clause as well as hearsay. And what Mr. Dotson said, just for you to know, and I'm not saying the state is trying to use Mr. Dotson, but in case they are, it's a recorded interview. On the day of the incident, Mr. Dotson is with Detective Quinn. He's very animated. It's video, audio, and he's standing up and telling Detective Quinn, I saw Thug earlier. He saw that I had money on me. He wanted to know if the person who seemingly is selling lien has contacted me because he's not calling Jeffrey back. Jeffrey asked if he can use my phone. It must have been Jeffrey involved because his guy meaning Walter Murphy, his guy is the one who armed robbed me. So I'm moving to exclude that as well. And that is mentioned at times by Detective Quinn when he's interrogating Mr. Bean.
So the statement, you're asking to redact the statements of Dodson that Bean talks about, or what? During the September 17th interview?
Yes, so that's Detective Quinn repeating.
Because Dodson is deceased.
Right, and that would be confrontation clause.
All right.
And then, so it's three things, I guess. Anything that Mr. Dodson said, confrontation clause, anything that former detective or retired Detective Quinn said about his investigation to Mr. Bean, and then on the jail call, specifically the jail call with the unknown person, anything that person said, I don't believe it all fits into.
Why wouldn't Detective Quinn state? I mean, he's going to testify.
Yes, he's going to testify.
So why would I have to worry about anything that Detective Quinn says, because you're going to be able to examine him, right?
Right, but if he said, I'm making it up. He said, well, the reason I asked that question because Mr. Dodson told me that you would be getting an objection on confrontation clause because I can't cross-examine the speaker. That's what I'm saying.
Well, I'd have to take that up depending upon what he says.
Yes, I have no problem with his his in-court testimony. I'm more focused on the recordings, if the recordings are sought to be played.
All right, does the recording mention anything about Detective Quinn referencing statements by Dodson or?
Yeah, the jail calls. He plays the jail calls in the recording.
Okay, all right.
And that's all I want redacted. I don't mind anything about what you said is correct. Adrian Bean's going to testify whatever he said on jail call. If that's otherwise admissible, no problem. It's just a person.
Yeah,
exactly. That's it.
State, what do you, what's your take on first, like the September 13th phone calls from the jail on the unknown person?
Yes, Your Honor. So Mr. Bean is going to be testifying as a witness. And so the admissibility of those jail calls.
Worry about Bean. Tell me about the unknown person.
Yes.
How is there some theory that I'm going to be able to admit that?
Yes, Your Honor. So
what is that?
Jones v. State, which is 339 Georgia App 95. It's a 2016 Georgia Court of Appeals case.
What's the site again?
It is 339 Golf Alpha.
Okay.
Yes, Your Honor. 95. That case involves an informant jail call with the defendant. They didn't have that informant testify at trial, and the pin site for this is 101, and then it carries over into 102. Trial court ruled that the informant's statements were admissible to provide context for Jones's responses to those statements, not that the informant's statements were admitted to prove the truth of the matter asserted. And then they go on to say that the defendant's own statements, of course, are a statement of party opponent. The reason that, Your Honor, I started with Mr. Bean and his testimony is because these jail calls, if they come in at trial, would be after Adrian Bean has testified to impeach what he does or does not say. So it kind of hinges on the questions asked of Mr. Bean, how he responds to those questions, and if the state can impeach him with these jail calls, that's when these jail calls would come in. And Your Honor, I'll give you a brief example that Mr. Steele kind of highlighted that explains why this Jones case is important.
So you're not are you telling the court that you're not seeking to introduce these jail calls at this time here, but they're dependent upon what Mr. Bean says?
Correct, Your Honor.
Okay. All right.
And Your Honor, if the court would like, I can continue, or there was an example I was going to use to explain why this other party's statements could potentially be needed to impeach Mr. Bean. There's an example where that individual says, Thug says when Big Fred jumped out of the car, the police were still shooting. Mr. Bean responds, hell no, that blank probably shot because him and Big Fred and DK had the strap. So if you just played where Adrian Bean says him, it's in relation to this statement that immediately precedes it, where he says, "Thug says." So that's just one example, Your Honor, that may or may not come out. It all depends on how Mr. Bean testifies, who of course is subject to cross-examination, will be on the stand in person.
Okay, but there's a fair number of statements from an unknown person that, you all have the tape queued up.
I do, Your Honor.
Okay. Let me hear it, or the call, just mark it as a exhibit for purposes of,
Yes, Your Honor.
motion.
There's multiple jail calls. I'll pick one where this individual speaks as an example for the court.
He's talking, Mr. Seals identified, the first one is 4:30. There's an unknown male talking, so start it maybe about 4 minutes out.
Yes, Your Honor. Ms. Kern, can you give me screen sharing? Yes, thank you, sir.
Call from
Hazel.
an inmate at Fulton County Jail. This call is subject to recording and monitoring. To accept this free call, press 1. To refuse this free call, press 2. We thank you for using Securus. You may start the conversation now.
What up, man?
I'm really fine.
Shit. Ain't no hot ass nigga, man. Them nigga down there got a nigga killed, boy. Fuck you talking about? Man, I said that shit. Little nigga DK shot at 12, nigga. Yeah, they said it. No reason. Bro, when the high level.
No. I don't know, man. I got AJ. We came home. I'm sure the food came over. They came over about 8 o'clock.
Mm-hmm.
Yeah, they do. So we
Nah,
both
let me
came
get
out.
right quick so I can tell them something right quick.
Go.
Roll out.
I do this shit. I don't know.
Your Honor, and that's what the right before this third party gets on the call at 4 minutes.
So you got minutes on the phone. Bro, what's up, man? What to do, Brody? Right. Hell yeah, man. I just talked to another story, man. What they talking about? Shit. Man, I know how that nigga, man, them nigga down there got a nigga killed, boy. Fuck you talking about, man? I said that shit, DK, little nigga DK shot at 12, nigga. Yeah, he said it. For no reason, boy. He shooting for no reason, though. That's why they started shooting that shot. Man, that nigga just started busting for no reason. Called the little young guy there. I'm like, hell no, boy. Hit big friend, hit his ass. Me and Thug got there. We get out the car and run. I just went the wrong motherfucking way, man. I should have fought Thug there. But that was for a reason, though, man. They got to get this shit off his back anyway. For sure, bro. Yeah. Hello? Yeah, I'm here. Yeah, man. Damn, bro. We had to go like that, man. Nah. Everything for a reason, though, man. You know what I mean? It was all set up. I did the same thing I did. Sit around, goddamn, last night, goddamn, talking that bullshit. But I ain't gonna never goddamn do it like this. I never do this, man. Can't no shit. They got your charge with, bro. Shit, but little punk ass little driving license, split a license, little charge, goddamn, the aggravated assault. I ain't charged with none of that shit today. I could have gave AC nothing and been at home, child, man. Yeah, that's what I thought we did. I just thought that I was a victim, man. I had to take out Raw, man, and they was shooting at me, and I was running for my life. For sure. That was something they called out there, and APDK them pull out on that boy. All they know is red, them that nigga real trying to rob y'all. Yeah, that's what they said, too. For sure. They just let that nigga out. Around, man. They just let that nigga go, bro. Yeah, they let the nigga go, man. Me and that nigga, he ran. I went too far from him. No. He went to Mickey D, nigga. I went from around the laundromat to goddamn that Dollar King over there, trying to make it over there through Little Haiti. For Cleveland E, goddamn, up through the top of that, and I go hit Jamal in my old apartments, goddamn, go down there, chill with Big Nick, you know. But shit, man, that whole goddamn come out of nowhere, boy, run me clean over. That was goddamn, that was thorough, man. Big Nick out. Yeah.
I need to hit the car.
Yeah, they ran me smack ass low, man. My mom broke my goddamn collarbone and shit, man. You alright over there, bro? Big ass knot on the back of my head. That nigga escaped, joined the police back to the spot, bro. He did. Yeah.
Okay.
Hey, you know, they're trying to get the fucking call? What they told him, bring him to the person who he let the car to. No, he's come up, goddamn. I've been down here chilling with Bean. He been staying down here and all this and shit. Them folks are fucked up. Yeah. You don't even look like a nigga to survive in that motherfucker. Fuck you, my nigga.
That shit,
man.
That shit breaking news all day long, man. It's like that busy on news all day long.
I'm on the news?
Yes, sir.
My picture and everything?
No, I just show you get the police on.
Oh, shit, man. I made the news.
That shit everywhere, man.
Damn.
Yeah.
Man, that was shit out, man. You know, like I said, everybody out for a reason, though, man. Fuck it. For sure. I don't do shit with niggas like that anyway, so. For sure. Man, that's sad, man.
But I can't even think about this. All I can think about all them I just told, babe. You know what I'm saying? Like, this shit crazy. This shit don't even seem real.
Fuck, man, broke up with these niggas, man.
You drive your own shit. I don't give a fuck what's going on. You feel what I'm saying?
Because, like, nigga, you just stay here. We went to Ken Shop first, right? But, you know, when you see shit, man, you gotta go on and get that shit. You know what I'm saying? I was going to get it, bro. I said the same thing. Man, when you see it, you gotta go on and get it right then. Man, we got them going back up to the Ken Shop. Okay, they coming out of Ken Shop right there by the Chevron. Boom. Damn, man, they ride I see them being, I turn around, I'm following them nigga. I follow them nigga all the way up there on Summerdale. So, okay, cool. As soon as we see the tire, I said, give me a chance and let me see what the fuck this is in the tire first before you even get out the car, DK. Man, that nigga hopped out the car, man, we just started busting. Wow. 12 got them bag up, turn around, bag up. Niggas by that time, they're trying to turn around and get up out them motherfuckers. They run and hit me. Boom. Fuck the car. I rushed clean through the goddamn gate, through Summerdale on the opposite side. Boom. He shooting through the car. Boom, 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 boom. Man, I'm talking about, man, I'm talking about bullet car sprint clean through the window, boy, down the like it had went through my head, boy. I got my head and came out my face, boy. Bullet car clean through that motherfucker. Boom. Then I believe one of them niggas in the back shot me 12, man. 12 shit. Big gun, DK had to shoot that nigga because 3 shots went off in the car. And we were jumping them hills and shit. So I was like, damn, boy. After we sprayed, I'm glad one nigga didn't just hit me in the head to shoot me, boy, because some nigga went. That nigga said goddamn Big Fred got out of the car, the police shot, they was still shooting. Nah, that nigga probably shot Big Cook. Him, Big Fred, and goddamn DK had to scrap. I wouldn't even scrap my 22 at home and my AR in the trunk. You get that $150 out cup holder, bro. No. You got that $150 out my cup holder. No, someone say you had $150 go buy the ring. Nah, man. Well, no money in the cup holder, bro. No, my motherfucking money. Yeah, he said he had the money to go buy the ring. No, I had never $50, $40. He didn't have that because DK didn't even get him his 50. All that money was mine, and money came out of Buck hands. So he ain't had no business doing that. He made Buck goddamn come off 100. I told him, hell no, nigga goddamn go 50, you go 50. Nah, Buck said nigga, you don't want to 50. No, they gave me nothing. I had a 50 of my own money. I had $350. They got $345. I got to let Bay come down here and goddamn go to profit and get that shit. Come down here and sign a piece of paper. I got to fill out a profit release form or a waiver form. So she can go down there and get a little $350. You know what I mean? And that gonna be that. I don't think I just gotta do it, goddamn, just try to make sure this lame don't even come to court with dad, goddamn, because they talking about the old man and that old boy. So, yeah, for sure, you know, I'm gonna take care of that too, bro. You know, I'm gonna talk to these folks. You know, he come, you know, I mean, cool with it. So, yeah, we're gonna try to keep his ass out of that, though. I can't get no more some probation, man. I ain't got no probation, no record, no none of that shit, man. You know what I mean? I don't shoot, folks. Yeah, we trying to get your ass out, man. So get a burn, man. I don't rob. I don't do none of that shit. So, you know what I mean? I don't have none of that shit on my record. So, I'm good, man. I'm just talking to Cub, man. Cub ready, man. Oh, we? Mm-hmm. Oh, y'all let him? Yeah, I talked to him.
Yeah, he came over and talked to him yesterday.
What'd he say?
Shit. He ain't say shit.
Yeah, goddamn, he got some bad, whatever, goddamn, you know what I mean?
Nah, cuz, you know, he just said, you know, in that moment.
Yeah, he was trying to think about what he done did and all that.
Yeah.
But I ain't did shit, so he know I got something going on. He got to go and get me, because I got something going on. For sure, man. I'm coming back to you.
Oh, shit, cuz, I know you late.
Love you, too. I got 1 minute.
Nah, I ain't saying shit, man.
Oh, you said it, man. What you want me to do about allowing them in the car note in the rent, bro? Huh? What you want me to do about allowing with the car notes in the rent? Shit, that's what I was saying. I got these little $345 my just gonna put in the rent. Car note gonna be goddamn a couple of more days. What do we got? How long we got on the car note? About 10 days? Yeah, bro. Huh? You want me to pay the rent first? Yeah, I gotta get that rent. That's what I was working on this time, that rent. Yeah, what's up? I got that, man. Don't worry about it. Let me take care of that. Probably just need like $6. I got $345 downtown, man. They ain't my money. You know, I got the rest of the money you gave me and that good lockdown and shit. I'm gonna get the rest of that money.
The caller has hung up.
Okay, so what exhibit was that number, sir?
Your Honor, I will mark that. Your Honor, I will mark this jail call as Mike Tango November 4 November.
Okay, so what's, from listening to that, jail call, how are you claiming that this completes the context, I should say? How do you claim provides context?
Yes, Your Honor. So an example would be in that exhibit that was just played, kind of near time at 9:38. So say Mr. Bean said no one had any firearms in the car. And you have this statement from Adrian Bean where he says, him, Big Fred, and DK had the strap. I wasn't strapped because mine, 22 and AR in the trunk. That jail call portion of Adrian Bean, who's testifying, where he says him, Big Fred, and DK had the strap, to give context to who he means by him, the immediate seconds before it is where that party says, Thug says when Big Fred jumped out of the car, the police were still shooting. So the state's not trying to introduce Thug says when Big Fred jumped out of the car, the police were still shooting. For the truth of that statement is to give context to Adrian Bean when he's mentioning him and the parties. That's one example that I think highlights where this could come up. And all of this is couched under how Adrian Bean himself testifies. It may be a situation where no jail calls ever need to come in to impeach. It just depends on how he testifies on the stand, Your Honor.
Okay. So you're not planning on playing what's in state's, I should say, motion number 4, jail call, unless depending upon how Mr. Bean testifies?
That is correct, Your Honor.
Okay, all right. Mr. Steele? Makes sense.
Yeah, I don't think that the context will be needed. Mr. Bean, in his statement, which is recorded to Detective Quinn on the 17th day of September 2013, was asked to account for the guns, and he states there, Jeffrey Williams calls him Young Thug, Mr. Murphy, he calls him DK, and Mr. Prethro. But I understand what the state said, so I'm just assuming we'll take it up then because
it depends on how he testifies.
I understood.
Would be that. Let me deal with the other issue of what about the statements by Mr. Dodson, who's deceased, in the September interview.
Yes, Your Honor. The state is not intending on playing the deceased Mr. Dodson's statement to Detective Quinn.
Well, what, no, in the 17 September interview of Mr. Bean, does he reference Mr. Dodson?
Mr. Dodson is discussed, Your Honor. That interview, I'm trying to think, because with the motions that were filed, I did not have the time hack for Derek Dodson's reference with Adrian Bean's statement. I focused on the jail calls. However, I will look at the context of that and pull it up now, Your Honor, to see how he's referenced. And Detective Quinn is also coming to testify. And so, depending on how Mr. Bean testifies, I think impeachment of Mr. Bean could come either from Detective Quinn's own mouth as an impeaching witness or portions of that statement. So I think that is best addressed after Adrian Bean testifies, because neither the jail call or his interview will be coming in before Mr. Bean himself has testified and been subject to cross-examination.
And it may not come in then, right?
Correct, Your Honor.
All right. Mr. Steele?
If I'm tracking, Your Honor, I understand we're going to wait. That's what it sounds like. It may not, at this point, no one's playing it, and if it becomes right, we have to raise it to the attention of the court. If I'm wrong.
No, you're correct. My only concern is depending upon what Mr. Bean says, the 17th of September interview that may reference a decedent would maybe a problem. That may or may not, we may or may not get to it.
I understand.
But Mr. Steele's assertion is that because Dodson's deceased, that references to him, that Miss Dodson, would be hearsay and confrontation. But you may not get to them.
Yeah, that's the state's assertion, Your Honor, at this time.
Okay, but I'll tell you right now, you're gonna have a problem if Bean's interview states a decedent third party. I'm just gonna tell you that right now. So I think that depending upon how, you can cross that bridge when you get to it, depending upon how Mr. Bean testifies. But before you start playing an interview that references a third party decedent, we need to relook that issue, okay?
Understood, Your Honor.
Okay, all right. So I'll continue for a ruling on that issue until we hear whether or not Mr. Bean's phone call on the 13th of September becomes relevant, as well as his interview on the 17th of September becomes relevant. Okay?
Thank you, Your Honor.
All right. Okay, let's talk about the DNA reports for overt acts 5, 6, and 7 that were supposedly served by the state on the 19th of January, 2024. Are there DNA reports that were served or disclosed?
Yes, sir.
Okay, all right.
Yeah, and this is motion limiting of Mr. Williams, number 43.
Yes, sir.
So what happened is it's the same incident. It's overt act 5, 6, and 7. There is mention in the discovery before January 19, 2024. There's mention early on, Investigator Crandall, he's with the Fulton County District Attorney's Office at that time. He states in his memo about this incident that did not charge Mr. Williams when it was prosecuted originally in 2013, 2014, that the DNA came back. There was DNA and it comes back to Mr. Walter Murphy. That's the only DNA I have at all on the case. Then on the 19th, for the first time, I have a DNA report. And what the report says
is it was written in 2014, Your Honor. I have to check my memory better, but I'm going to tell you it was early 2014. April 10, the Honorable Mr. Adams said 2014. And what it basically says is there are 3 guns. We could show you a copy, actually, if you need to see it, but there are 3 guns found in this car that careened off and into the laundromat. 3 guns are recovered. DNA from one of the guns comes back to Mr. Walter Murphy. The other, there's more DNA that cannot be traced back to anyone. The suspects, as the court may be familiar on GBI crime lab reports, it says that the victim is Mr. Dotson and the 3 suspects are Mr. Prothro, Mr. Murphy, and Mr. Bean. So then, the first time I see this is January 19, 2024. Then on January 25th, 2024, the prosecution served for the first time the CD of Dr. DNA expert, I pronounce it Pfeiffer, P-E-I. CD or CV? CV, so you're right, CV. Okay. His resume, CV. P-I-E-F-F-E-R. He's now with ATF. Okay. Still doing DNA. I called him, the Honorable President Hilton gave me his number. I believe it was yesterday. I couldn't find his number. And I emailed him. He returned my call today. I called him yesterday. I emailed him today or yesterday as well. He did call me back today, and he said we could schedule a time to meet. I've also contacted DNA experts. They need more information. But, Your Honor, expert Pfeiffer has never been on any of the witness lists. I'm including any of the witness lists, 770 people, whatever the number is. Never been mentioned before in discovery. And I was under the impression that there is no DNA whatsoever. And now I find myself in the midst of trial trying to understand if this is exculpatory. I know it doesn't mention Mr. Williams. I understand that. But the way the report reads, and I do have to speak with the expert, but the way the report reads is that it's inconclusive whose DNA is in there. So I want to know, why is it inconclusive? So I've spoken with, the court may be familiar with Dr. Hampikian. He's a DNA expert. I've spoken with other DNA experts, and they are figuring out from the one report whether this DNA can be extracted and tested after, they have no idea, basically. When are you supposed to meet with Dr. Pfeiffer? He said that he could be available today or tomorrow. So I have to email him back once court ends. And once you talk with him, will you be able to determine whether or not you will need more I think so. information? Yeah, I may need to, I'm dangerous because I've done DNA cases, but I don't know what I'm doing. So I probably need to have an expert on the phone with me with his permission to make sure that I'm not misunderstanding what he's telling me or asking proper questions. So I'm probably going to have to coordinate with another expert and get their times as well. But I will do that. But my bottom line, Your Honor, is the same thing, that I wrote in my motion. I really don't want this coming in at all. I don't know why I got it late. It was back in 2014 is when the report was generated. I don't know why he's not on any witness list. It's just, to me, I'm in the middle of trial. This is a big case to me. And what I mean that, there's so many people that we're interviewing constantly, Mr. Adams and myself, as well as the team. It's not just Mr. Adams and myself. There's a bunch of people trying to do this. And at some point, I just don't think it's right. So that's why I raised it to the court. And I'm not saying it's inculpatory. The state never said it was inculpatory. That's my concern also about a blanket exclusion. And that's why the appellate courts have indicated that the remedy is, the first remedy should be for you to have more time to investigate that particular issue of continuance. So without me knowing or the court knowing the flavor of the evidence, because it may be inculpatory or exculpatory to you and inculpatory to somebody else. So without hearing from that expert or getting the ground truth, I'd be hesitant to rule upon that issue to begin with.
Okay.
At this point, but I mean, I share your concern in terms of, we keep kind of having to kind of address this issue, but it's the best one that I have at this point in time.
Can I mention one other thing before I sit down? I just want you to know, and I am not casting aspersions at the prosecution, but remember the court ordered, hey, get them a real witness list by a certain date, and the state pared down to 400 and, I don't know the number, 80 witnesses. I don't remember the number. There were 6 people for Adrian B.
6 what?
6 people to testify about the overt act 5, 6, and 7. There are now 17, including this doctor who's never even mentioned or his report. So it concerns me that this is how we're treating each other. And I'm not saying it was done for gamemanship, but it was done for whatever reason, oversight, whatever. So anyway, that's my concern. But I will speak with him. But I do want the court to realize that I am asking, unless it's exculpatory, for total exclusion, even if it's even. I shouldn't be finding an expert at this point in time. That's my concern.
All right. Well, once you speak with with Dr. Pfeiffer, you can update me accordingly. But State, why are we proliferating witnesses now? I kind of told you all about that to begin with. I'm not real happy about that. So why is our witness list growing in terms of Acts 5, 6, and 7?
So first, Your Honor, this is January 19th, 2024 was not the first time that this report was disclosed. Your Honor, this report was disclosed actually in the first round of discovery in July 11th of 2022. It was then reserved again in September of 2023 when we did the consolidated grouping of evidence. And I can show or direct Mr. Steele to where exactly this was served previously. So January 19th, 2024 is not the first time that this report has been disclosed. It was disclosed again back in the first round of discovery in July of 2022. And then again, when we did the consolidated discovery in September of 2023, Your Honor. As far as the witness list goes, Your Honor, I believe that this list of individuals, as we are preparing the case, these are individuals that were on the original witness list that we served, except for Mr. Pfeiffer, and we'll talk about that in a moment. But the list from 6 to 17, as we are preparing our cases, we're identifying who we need in order to make sure hearsay objections are resolved, or that we need certain witnesses to get certain evidence in. So as we're prepping the case, we're realizing who we need in order to prove that case in front of this jury. And so that is why the list may have went from 6 to 17, but we have consistently.
I don't believe, that I'm kind of very suspect about that.
About which part, Your Honor?
You all indicted the case. We've been through this thing about almost about a year now. So why is it that you didn't know? I mean, it's one thing if you got one witness, okay? But, I share Mr. Steele's concern that if you have a proliferation of witnesses, I'm thinking I'm going to have to deal with like 2 or 3 witnesses for a particular issue, but I got to now deal with 10. I might have some trouble with in the sense that I need to look at and also interview everybody. And what it does for me as your trial judge is it kind of, I got to stop like I'm doing now and kind of look at things and determine whether or not, or give people the remedy of a continuance.
But Your Honor, first, as far as the witnesses, there's only one witness that they're saying is at issue, not the 17. They're only claiming that one person is of issue, that's Pfeiffer, because they've had the list of individuals that we've been on calling for Adrian Bean, I think, and I want to confirm since December.
When did you get Pfeiffer?
We added Pfeiffer, I believe, and I want someone to double check, when we started providing who we were calling for those witnesses. I think Pfeiffer may have been on that initial list, but I want to double check. But definitely by January, we knew that Pfeiffer might be called. And so we added him on that list that we've been providing when we thought we were going to bring this case up in January, that Pfeiffer was on that list.
Was Pfeiffer on the July 11th or the July 11, 22 or the September 2023 list?
Pfeiffer was not on the expanded witness list, but he was on the list of individuals that we said, these are the people we're going to be calling for this case. So when we narrowed
What date was
down,
that? What date was that?
I need to look and see when the first iteration of that we sent out. And that was either December or January. So on January 5th, 2024, as a matter of fact, I have a December 31st list. On December 29th, Your Honor, we sent to all defense counsel the list of witnesses that we intend to call for all the cases that were coming up. And Pfeiffer is on that list. And when we pared down who we were going to call for this particular case, we listed everyone we intended on calling on this particular case. And that is from the 29th of December. So this is not anything new. This is who we've put on this list consistently since we've been providing the shortened list of who we were going to be calling. And again, Your Honor, the state may have inadvertently left Mr. Pfeiffer off of the master list, but he has been in discovery since July of 2022. So this is not anything new, Your Honor. So we would ask that this report not be excluded. Mr. Steele has had the opportunity to at least have an initial conversation with him and potentially we'll have any further conversations, Your Honor. But first and foremost, this is not the first time that we disclosed it on the 19th, and they've been aware that we were going to call this particular witness at least since December when we were given the pared down list of who we were going to call and that we intend to do so that we can move forward with this trial, Your Honor.
When's Mr. Pfeiffer, Dr. Pfeiffer going to be called?
Your Honor, it will be all really contingent upon what happens with Investigator Belknap. We perceive that this particular case will be called next week. Mr. Pfeiffer lives out of state, and so it's the state's intentions to fly him in so he can testify on a particular day, but we're just trying to figure out once Investigator Belknap's testimony is completed, we're trying to determine when we will fly him in, but ideally it will be at some point in time next week, Your Honor.
Okay, all right. Mr. Steele, I'm not going to exclude the report from Dr. Pfeiffer, but I will give you enough time to talk with him and to make other arrangements should they become necessary. So see what he says and you can report back to me, okay?
Yes, sir.
Okay. All right, folks, that's kind of I think that's a wrap for today in terms of what we're going to be able to take up in terms of, so we covered 42 and 43, and continue to defer on 40, and we'll take up the other questions before those witnesses are called, okay? All right, what are the... All right, what are your questions of me, Eddie? All right. Okay, we will then see everybody tomorrow morning for 9 o'clock. And once everyone is accounted for, we'll go ahead and go ahead and get started, hopefully somewhere between 9 and 9:30, okay? Unless there's anything else of me, then we'll be in recess until tomorrow morning, okay? All right, we're in recess. All right. Okay.